Please welcome Professor Wendell Carter Snead.
Thank you so much, Mark. It's so great to be able to be with you all here this evening. It's all right. So, I'm a huge fan of this Hesburgh lecture series. It's an extraordinary opportunity for us, faculty at Notre Dame, to interact with you wonderful alumni. Dolly Duffy and her team at the Alumni Association are extraordinary. This is just a great way for us all to be together, albeit not as intimate as it might be setting. We have a large group here, which is great. To talk about interesting questions that us faculty are working on, and it just so happens that the matter that I've been working on for the past year, really for the past 20 years, has really come to a head in the past week. And the plan, even prior to the events of the past few days, was for me to come and talk to you about abortion law and policy generally in the United States, jurisprudence, Roe v. Wade, the life issues, and how they all intersect with each other. And with this recent development, we're actually watching history unfold as we speak. So my remarks this evening are going to be, my prepared remarks are going to be somewhat brief. I don't want to get deep into the legal or jurisprudential weeds with you, but what I'd like to do is kind of give you a sense of how we got here, how we got to this point in our nation's law and public policy, what happened in 1973 that transformed not just law, not just jurisprudence of constitutional law, not just the practice of medicine or the concept of parenthood or even the concept of citizenship in the United States and the role of the states in protecting the weakest and most vulnerable. It was an extraordinary, catastrophic event of epic proportions that happened in 1973. And then from then until now, it's been a struggle for those of us who believe in the intrinsic equal dignity of every human being, born and unborn, to try to make sure that everyone is, as Pope John Paul II said, welcomed into life and protected in the law. It's been a struggle, and it looks like we may be, God willing, nearing the end of that struggle. We'll see. We don't want to count chickens before they're hatched. But I'm going to give you the kind of the jurisprudential arc, the twists and turns, beginning in 1973 up until the present day. And then I'm going to talk a little bit about where we are now, what has happened this week, and what we can make of it, and then we'll sort of pivot and talk about what it means for the future, both the near future and the longer term future. So, and again, I prefer interactive encounters, as you probably do as well. So if people want to intervene, if you have a question or a comment or something that strikes you, you just want to say it in the middle of the talk, we treat this like a class. You can raise your hand, and if I'm at a stopping place, I'll recognize you. We can have an exchange. Or if you prefer just to wait till the end of the prepared remarks, that's fine too. And I just want you to feel free to engage in back and forth if that's what you would like to do. So let's start back in 1973. Let's start the day before Roe v. Wade was decided. Roe v. Wade was decided in January of 1973. It was the culmination of a case that had begun in Texas several years before that. It was a lawsuit brought by several plaintiffs challenging the Texas law that banned abortion, except in those cases where an abortion was indicated or necessary to save a woman's life. There was a life of a mother exception in Texas abortion law that was challenged. And because of an unusual statute that governed the certain kinds of challenges that case represented at the time, challenging a state criminal provision in a federal court, it was heard by a 3-judge trial court, which is unusual. Normally we only have 1 judge presiding over a trial. In this case, they had 3 judges. And the judges didn't take any evidence. They didn't have any hearing. And as you probably know, in the world of American law, the trial serves an essential truth-finding function. It's the adversarial system whereby expert witnesses or propositions of fact are challenged and established and then proven by a preponderance of the evidence or beyond reasonable doubt, depending on what the standard of proof is, depending on what kind of matter it is. But when there are disputes of fact in American law, they are settled by courts. So issues of medicine or science or sociology or history or whether the light was green or red, these are questions that you litigate and are heard by a trier of fact and resolved in that process. But that didn't happen in Roe v. Wade. What happened instead was this 3-judge panel heard the claims made by the different plaintiffs, including Jane Roe, real name Norma McCorvey, and those 3 judges decided, based on a pretty novel interpretation of a case called Griswold versus Connecticut from 1965 involving the right to contraception, in a concurring opinion, in that decision, a concurring opinion by Justice Goldberg, there was a reference to the Ninth Amendment, which was thought of as a pretty inchoate source of authority. They said, well, then we think the Texas law here banning abortion violates the Ninth Amendment, which I'm paraphrasing, the Ninth Amendment says that even though we haven't written down all the rights here, that the non-inclusion of certain rights in the Bill of Rights don't mean to disparage those rights or to deny the rights that are reposed and held by the people. Now you can see on its face, by my paraphrase, that's a pretty vague account. It's not clear what rights those refer to, and it had never been used as a real concrete source of authority until, in this concurring opinion in the contraception case, Justice Goldberg said, I think that might be a source of authority for this right to privacy that includes the right of married couples to use contraception without interference from the state. Because marital intimacy is important, privacy of the bedroom is important, and this right to privacy makes sense as one of the rights that are sort of implied by the Ninth Amendment. And so this three-judge panel says, okay, we're persuaded by that. We think that's true here. However, there's a principle that when a federal court is called upon to invalidate a state criminal provision, sometimes this federal court will abstain from doing so. They'll say, okay, we declare this to be unconstitutional, but we're not going to nullify the law based on this principle of abstention. Okay? And so that's what they did. They said the law is unconstitutional under the Ninth Amendment. We're not going to take testimony. We're not going to hear evidence. We're not going to discuss when life begins or the relative safety of abortion and childbirth. We're not going to talk about the history of abortion and how is it treated in American law. None of that, right? We're just going to declare as a matter of law that this violates the Ninth Amendment, but we're not really going to do anything about it because we think that it's appropriate to abstain and defer to the state criminal provision at issue. And so, by operation of a statute that doesn't exist anymore, the plaintiffs were able to appeal that, and everyone was able to appeal it directly to the United States Supreme Court without going through an intermediate appellate court, which is the usual course of affairs in the pathway of a federal lawsuit. Went straight to the Supreme Court. And why do I keep talking about the fact that there was no trial record? Why do I keep talking about the fact that there were no facts established at the trial court? It's because appellate courts, and especially the Supreme Court, are not designed to adjudicate the veracity or validity of facts, or certainly not to adjudicate factual disputes. That's for a trial court. Trial courts are meant to do that. The trier of fact, sometimes a jury, sometimes a judge sitting as a trier of fact, has to listen to the testimony, decide what the truth of the matter is, and then make a finding as to what the truth of the matter is. But none of that happened. It came straight up to the Supreme Court as a matter of law, and then the case was reheard a couple times because of vacancies on the court. But ultimately, in a 7-2 decision, the Supreme Court of the United States declared that the Texas law at issue implicated a fundamental right to abortion, which was implicit in this right to privacy that had been discovered in the Griswold case. That the right to privacy, which was rooted in the concept of marital intimacy and the sanctity of the home, also extended to include the right to abortion. But the Supreme Court said it's not the Ninth Amendment that matters, it's actually the 14th Amendment that is the source of authority. So when the court strikes down a law, when a duly enacted law by the political branch of government is struck down, the court has to point to what provision of the United States Constitution it violates. And in this case, the Justice Blackmun said the 14th Amendment due process clause, which says no person shall be deprived of life, liberty, or property without due process of law, ratified in 1868, at a time, by the way, in which abortion was criminalized by statute in 3/4 of the states in the United States in 1868. So no one in 1868 thought that by ratifying the 14th Amendment, they were precluding the authority of the states to regulate or even ban abortion. States already banned abortion. The states that ratified the 14th Amendment had abortion bans on the books that they didn't expect would be changed by that. And in fact, some states, Ohio, for example, tightened up and made even more restrictive their abortion laws in the months following ratification of the 14th Amendment. And if you look at the legislative record of the Ohio legislature, it says we're going to ban abortion from conception because it's tantamount, and I'm borrowing the words directly from the legislative report, child murder. So why am I bringing this up? Well, the job of the Supreme Court is to interpret the Constitution, right? And the court said that a provision adopted in 1868, which is a purely procedural concept, a the concept of procedural due process, that you're entitled, the state can take away your life, liberty, or property, but in order to do it, it has to provide you with due process. It's merely a procedural safeguard. It's that procedural language guarantees a right to privacy that includes a right to abortion. Even though no one living contemporaneously, the drafters, people living in the United States, state legislators, nobody thought that that's what that language meant. In fact, no one thought that that's what that language meant until the end of the 20th century. For 185 years, no one thought that the 14th Amendment forbade states from protecting unborn children in the law. It was a novel idea, and so where did this idea come from exactly? The idea came from Justice Blackmun's own freewheeling philosophizing and resort to consideration of facts that were never in evidence at trial. He has this long passage in Roe v. Wade about the history of abortion in America. He wanted to establish the proposition, the false proposition, that there was a liberty interest in getting an abortion in the United States prior to the middle of the 19th century. It was completely false. Why did he think it was true? Because there were two law review articles written by a man named Cyril Means, who was general counsel for NARAL, the National Abortion Rights Action League, although he didn't identify him as such in the article. Two articles in which he claimed falsely that abortion only became criminalized in the United States in the middle of the 19th century. So Justice Blackmun was trying to establish the proposition that there was not a long-standing tradition in the United States law and policy and culture of restricting abortion. But of course that's false. Abortion was a crime in common law even prior to the American founding. There are examples of indictments of abortionists from before the American Republic was founded, and certainly after the American Republic was founded. And it was the advent of the 19th century that states shifted from the common law prohibitions on abortion to codifying in the criminal code bans on abortion, but it still didn't, there certainly was no liberty interest in abortion. But Justice Blackmun said falsely that there was, based on these law review articles, which were completely fabricated. It was not a version of history that anyone had subscribed to up until that point. But Justice Blackmun cites it 6 times, these articles 6 times in Roe v. Wade. Why does that matter? Well, it matters because the historical record is something that can be presented at trial and can be litigated and established as a matter of fact. That didn't happen. All Justice Blackmun had was his own rank speculation about the nature of the history of abortion regulation in the United States. And then he has this very meandering section about the way abortion was treated in antiquity and in ancient Rome, and basically trying to establish the proposition that no one really knows when life begins. No one really, there have been differing approaches to the question of abortion and infanticide, and it's not really for the court to take a position on that. But, nevertheless, the court says in Roe v. Wade that there is a fundamental right to abortion because it balanced what Justice Blackmun viewed as the burdens of unwanted pregnancy and parenthood against the state interests in protecting what the court described as potential life, which is biologically an unintelligible concept, right? It's not potential life, it is literally a life in process. We've known that since the middle of the 19th century, when fertilization begins and you have a distinct organism that directs its own development along a species-specific trajectory that eventually becomes recognizable in form and function as a member of the human species, but is ab initio a distinct living human member of the species Homo sapiens. It is not an inchoate cluster of cells. It's a separate life in process, right? But nevertheless, they gloss over that, and they say, and Justice Blackmun spends a lot of time focusing on the question of the distinctive burdens, which are inarguably burdens. We should be clear about that, right? The burdens and trauma of unwanted pregnancy. But mostly he talks about not the physical or psychic burdens of pregnancy. Mostly he talks about the psychic and physical and social burdens of parenthood. He talks about the taxing of the community by bringing into the world a child who is unwanted, by the stigma of unwed motherhood once the child is already born. Things that aren't problems that one could deal with without resort to abortion, right? But nevertheless, he builds up this very significant and genuinely true set of burdens that accompany unwanted pregnancy and parenthood. and then compares them to what the state articulates as its own interest in protecting potential life. And what he comes up with, he says the 14th Amendment has this right to privacy, and this right to privacy must be robust enough to include a woman's freedom to decide for herself, without interference from the state, about how to deal with this unique burden, how to unburden herself. She must be able to have recourse to abortion in the event of contraceptive failure, in the event of an unplanned pregnancy, in order to be free from these burdens. And the state cannot insist upon one definition of when life begins. Now, at the same time, the court was claiming to be agnostic about what the question of the moral status of the unborn child. So we're not going to settle the question of the moral status of the unborn child, but of course it did implicitly by denying the state the freedom or the authority to treat an unborn child as a human being. So if the court tells me, as the state of Indiana, that I'm not allowed to treat one class of persons as human beings, they can say that they're not taking a position on their moral status, but functionally they're declaring them to be less than human. Because if you're one of the hallmarks of personhood in American law and moral theory is that your status as a being isn't dependent upon the judgment of others. You have an independent status, and it must be the case that others are bound to respect the integrity of your body, to prevent, to not consume you in a way, or to adopt an extractive attitude towards you as if you're a resource. A person is different from a thing. And what the court says in Roe is that the state is forbidden by virtue of the 14th Amendment from treating the unborn child as a person. It's forbidden from doing so. And then it even has a separate passage where it discusses the interpretation of the word person in the 14th Amendment. It says no person should be deprived of life, liberty, or property without due process of law. The court says, well, the word person there can't mean unborn child, because in the 5 or 6 other usages of the word person in the Constitution, it's not referring to a prenatal human being, it's only postnatal human beings. Which, by the way, is not a very rigorous or comprehensive or powerful method of linguistic interpretation. He did that, but that was as far as the court was willing to go. They simply declared that the word person in the 14th Amendment does not refer to unborn children. And Justice Blackmun says in passing that if we thought that it did refer to unborn children, then the right to abortion would be null and void. Which, by the way, I think is actually not true. If there's a conflict of interest between two human beings, sometimes the law operates under principles of justification, necessity, and excuse that does allow the use of lethal violence of one person against another person. It's not simply the case that the law forbids all forms of killing. But to take Justice Blackmun's point, it certainly would make it difficult to have a robust freedom for abortion if the law were to recognize, or if the court would let the law recognize the equal moral status of the unborn child. So, you have to think for a moment about the radical nature of what the court did in 1973. Prior to 1973, abortion was criminalized in many jurisdictions. There was a kind of trend towards liberalization, a significant trend in the direction of liberalization in the 60s, which had actually turned back in the direction of restricting abortion once again. New York, for example, liberalized its laws on abortion, but then repealed its law liberalizing abortion and was going to recriminalize abortion, which was in a law that was vetoed by the Republican governor Nelson Rockefeller in the early 1970s. And so that was a moot point. But prior to for the 185 years of the existence of the American Republic, we were allowed to govern ourselves on the question of abortion. States had laws on abortion. States banned abortion. States criminalized abortion. Some states later on in the 20th century liberalized the laws of abortion. Some had middle positions, much like the rest of the world, which does not govern itself on the question of abortion through its court of last resort, but instead does so through its political deliberative process. But in 1973, because the court said there is a constitutional fundamental right to privacy that is unenumerated, nowhere mentioned in the Constitution, that we read into the Due Process Clause, that includes the right to abortion, that means that the states can basically not restrict abortion in any meaningful way. And that, let me tell you, is a novel idea. It's an idea that virtually no one had until the latter part of the 20th century. And again, we have to continually remind ourselves what the court's doing in Roe. What they're supposed to be doing is interpreting the Constitution. The court is not empowered simply to do politics. It's not empowered to simply say, what do I think the best policy on abortion for America is? Here it is. I think there should be a ban in the first trimester and on restrictions and so on. That's not the job of the court. The court's job is to interpret the Constitution and to see if the requirements of the Constitution conflict with the state action at issue. So the idea that there's a right to privacy implicit in the 14th Amendment was itself controversial, but to extend that right to privacy to an obviously non-private act of intentionally killing a third being, another party in interest, whether another living member of the human family, that's different from the marital bed. That's different from the privacy of the home, protected from unreasonable searches and seizures. That's not a purely self-regarding act. That involves the direct and intentional violence against another being, and it involves a wide array of people. Henry Friendly, who was an iconic liberal judge in the 1970s on the U.S. Court of Appeals to the Second Circuit, was confronted with a question about whether or not the right to privacy, articulated in Griswold, was sufficient to prevent New York from banning abortion. And he concluded in his preliminary draft that no, he said there is a right to privacy, and it does include the protection of the private spheres, traditionally understood. But abortion is not that. Abortion is not a private act. It's not a merely self-regarding act, and it's not a private act in the conventional sense, in the spatial sense. It involves clinics and technicians and all kinds of doctors and nurses. It's not a private action. So no, he said the right to privacy exists, but it does not include a right to abortion. But then prior to the publication of his opinion, the New York legislature, as I said, changed its law. And so the case was mooted. Did you have a question?
Yes. Does the right to privacy end when the baby is born?
Well, let me bracket that question.
Okay.
It's a great question, but let's bracket it for a moment. So, 1973, bottom line is, right to privacy includes abortion. States can't do anything to restrict abortion. And that, again, is supposed to be a natural interpretation of the 14th Amendment Due Process Clause. But it gets even stranger. Justice Blackmun said, not only is there a right to abortion, it actually, the 14th Amendment implies a trimester framework. A trimester framework. It implies a trimester framework wherein during the first trimester of pregnancy, the state may not restrict abortion at all. In the second trimester of pregnancy, the state may not restrict abortion with the purpose of protecting unborn human life, but can restrict abortion for the sake of promoting maternal health. In the third trimester of pregnancy, Justice Blackmun said, the state may regulate abortion, it may restrict abortion if it wishes, but it must always make an exception, not just for the life of the mother, which the Texas law had, but also the health of the mother, which Roe v. Wade didn't define with particularity, but was defined implicitly in a companion case called Doe v. Bolton, decided on the very same day, which implied, at least, that the medical judgment relating to health included all aspects of a woman's well-being, not just physical health, not just mental or emotional health, but also financial health and familial health. So any aspect of a woman's well-being was sufficient to override the state's interest in restricting that particular abortion. And it was the abortionist himself who was to adjudicate whether or not that health interest was sufficiently weighty to override the state's strictures on abortion. Okay? Now, if that sounds complicated to you, if that sounds like a statute, it does. It sounds like a statute. It certainly doesn't sound like a natural interpretation of, quote, no person shall be denied life, liberty, or property without due process of law. But that's what the court said, under the doctrine of substantive due process, the idea that there are certain substantive rights that emerge that we can read into the Constitution, and then, of course, the question becomes, how does the court constrain itself in this discovery of new unwritten rights? How does it retain its authority as a court, its legitimacy as a court, by not simply reading its own policy preferences in to the document itself? How does the court figure out a way to avoid simply making things up under the false pretext of interpreting the text of the Constitution? And the court says, well, those liberties, those rights that are implicit in the concept of ordered liberty and that are essential for fundamental fairness, without which a legitimate system of justice couldn't exist, those are the kinds of rights that we can read into the due process clause. Those are the kinds of rights, if we don't have those in our system, no procedural safeguard is going to render our regime just and fair. Okay? So that was the analytic framework that the court was applying, and it was extremely controversial, not surprising, right? Substantive due process, the idea of identifying unwritten rights in the Constitution is itself fraught with peril because you're tempted, naturally, as a judge, to simply read in your own policy preferences without any constraint. It's unreviewable. Your life tenure, there's nobody that can stop you. The only thing that can stop you is your retirement or death, and then your replacement by some judge or justice that has a different view, or the amendment of the Constitution. That's the other way we could change it, right? So what the court did in Roe v. Wade was to sweep away the entire legal apparatus for abortion in the United States. It short-circuited the political process. It took the question away from the political branches altogether. It said, this is a matter of constitutional interpretation. You, in the political branches, have no place doing this. You have a very small space within which you can regulate this, at the margins, the question of abortion. But fundamentally, you are not welcome here. We are the arbiters of abortion in America because it is a creature of constitutional interpretation. And from 1973 until 1992, there was basically no meaningful restriction on abortion. And because the definition of health is defined so broadly in Doe v. Bolton, the effective rule from Roe v. Wade was not a trimester breakdown of a sliding scale of the right to abortion versus the state's interest in protecting maternal health or the life of the unborn child. It effectively meant a right to abortion on demand through 9 months of pregnancy, because ultimately you could always get an abortion if the abortion provider would aver that some aspect of your well-being, be it even economic or familial, would be implicated by and benefited from the abortion. So as a result, our regime of abortion in the United States puts us in the most extreme wing of legal paradigms for abortion anywhere in the world. There are only 7 countries, 7 or 8 countries around the world besides the United States that allows abortion through 9 months of pregnancy without meaningful limit. There's never been a single restriction on abortion, gestational limit on abortion, that has ever been affirmed by the United States Supreme Court. Not one. Okay? So and by the way, where did this trimester framework come from? It looks like a statute. It certainly didn't come from the history, text, or tradition of the Constitution. It came from Justice Blackmun, his own brainstorming about how best to govern abortion in America, based in part on his own speculation about the relative safety of abortion and childbirth. Now, if there's ever been a fact question that a trial court should resolve, it's that one. But he just, on his own accord, he was the former lawyer for the Mayo Clinic in Minneapolis, or actually in Rochester, Minnesota, and he had some doctor friends, and he just kind of figured it out himself. It is it's shocking when you say it out loud. So from 1973 until 1992, effectively there was no meaningful regulation of abortion in America, and people thought in 1992, because of the change in the composition of the Supreme Court, that the court was right to overturn Roe v. Wade. The opinion was criticized from the moment it was announced, not just because of the controversy about abortion, but because it was so badly reasoned. It didn't even pretend to be a serious reflection on the Constitution. Pro-choice scholars like John Hart Ely of Yale University Law School or Lawrence Tribe of Harvard were aghast that somehow this passed for a judicial opinion. They were happy with the result because they were strongly favorable towards abortion rights, but they thought it was kind of appalling how badly reasoned it was, how there was no evidence, how it was just basically freewheeling speculation and not very insightful or interesting analysis. So that's true from 73 to 92. You can't find anybody, in fact, if you think about the debate as it's unfolding right now, you can't really find anybody who will defend Roe v. Wade on its own terms. No one will defend it as an interpretive exercise of a way of interpreting the 14th Amendment. Now, there are some creative scholars who say, I can read the Constitution in a different way, look at a different provision to give you a right to abortion. But that's not Roe v. Wade. Okay, and Roe v. Wade is the precedent that binds our nation's courts and the political branches. Okay, so it's only Roe v. Wade that is of relevance when we're talking about the reasoning and the theory and its continued longevity, right? So the bottom line here is that Roe v. Wade was terribly reasoned, but nobody thought much of it because there was such consensus among the justices, 7-2, that everybody agreed on abortion. In fact, I think it was Lewis Powell's papers, I could be getting this wrong, but I think it was his papers, where he said something to the effect of, well, you know, the only people that really object to abortion are African Americans and Catholics, and the Catholics get used to anything, so they'll get over it. And he wasn't right about that, thankfully, because that it fanned into flames a controversy that has not been extinguished to this day. And in 1992, there was a great deal of enthusiasm and excitement, and a thought that, wow, we've got all these justices who clearly understand the failings of Roe as it's a piece of constitutional interpretation. Obviously, we're going to get Roe overturned. But it turns out, to the shock of many, in a 5-4 decision in 1992 in a case called Planned Parenthood versus Casey, the Supreme Court affirmed what it described as the core holding of Roe. Now it said, we're going to affirm the core holding of Roe. They even implied, well, so it's a fractured opinion, right? It's 5-4, but the main body of the opinion that people look at is this 3-justice plurality. The justices, the 3 justices who were expected, at least 2 of them were expected to overturn Roe, Sandra Day O'Connor, David Souter, and Anthony Kennedy, instead voted for the proposition that Roe should not be overturned. And so it sent shockwaves through the American public. People thought that was a surprising result. Pro-lifers were despondent, and pro-choice folks were relieved, obviously. And so what ended up happening was the new opinion did not seek to reaffirm the reasoning of Roe. In fact, it repudiated and abandoned most of what made Roe distinctive. It said, we don't believe there's a fundamental right to abortion. We think it's a protected liberty interest, which means it's not strict scrutiny when the court reviews state action that restricts abortion, which is the highest level of scrutiny the court can muster in evaluating challenged laws. We think that prior to viability, the right way to think about how to evaluate a law is whether or not it creates an undue burden on a woman's ultimate authority to seek and obtain an abortion. After viability, the court said in Casey, the state can restrict abortion or even ban abortion so long as it makes exceptions for the life of the mother, which all the laws did anyway, and the health of the mother. But then it didn't change in any way the Doe v. Bolton definition of health, which, by the way, was so open-ended it swallowed the rule. So that functionally the rule stayed the same, but it was the trimester framework was jettisoned in favor of this pre versus post-viability binary. Fundamental right out the window in favor of this concept of a protected liberty interest. And Justice Kennedy and his colleagues in the plurality thought, we want to give the states more latitude than they enjoyed under Roe to regulate abortion and to express their support and reverence for unborn human life. So undue burden, that's the right standard. Why did they do that? Why did they not overturn Roe v. Wade? They say, first, we're not going to overturn Roe v. Wade because we think that there's a liberty interest. Remember, privacy was the concept, and this is to your question. Privacy was the concept that operated in Roe. Justice Kennedy replaced it with liberty. There's a liberty interest in a woman deciding for herself what the demands of her life and her destiny require. And they have this grandiloquent passage, the mystery of life, the mystery of life has to be left to the, I'm paraphrasing, has to be left to the individual to decide. They have to be able to strike their own destiny and decide what life means for themselves without undue interference in the state, if liberty is to mean anything. And women have to be free to pursue their own destinies in a manner on an equal footing with men, and in order to do that, they have to have recourse to abortion. It's an essential freedom for women's flourishing in the social and economic space of the nation. It's essential. Okay, so that's the sort of substantive defense of abortion rights. But then it immediately pivots and says, but the real reason we're affirming Roe v. what we're calling the core holding of Roe v. Wade, which in fact is not the core holding, it's quite a different holding of Roe v. Wade, which matters for purposes of stare decisis, which I'll talk about in a moment. He says, we are not going to overturn Roe v. Wade because to do so would be too disruptive under principles of what we call stare decisis. It means to stand by the thing decided. Okay? That is, It's not enough that a prior decision was wrongly decided. It has to be the case that the prior decision has proven to be unworkable, has caused harm, has done damage jurisprudentially in other spheres, and there has not been a sufficient reliance interest, concrete reliance interest built up on it that would be destabilized if the law were to be overturned. And the court says, if we undid Roe v. Wade, all those things would be problems. The court said, I think mistakenly, that Roe v. Wade was still manageable as a rule. Well, they changed the rule. They completely abandoned the trimester framework and even the concept of the fundamental right, replaced it with liberty interest and the binary pre versus post liability framework. They said that the doctrine is not any worse today than it was. The legitimacy of the doctrine has not eroded over the past 19 years. But if that were the test, that means the very most badly reasoned decisions would be the most long-lived because they couldn't get any worse as time passes. And which is basically what you have in Roe. You have an essentially indefensible decision, which couldn't be worse. You can't, I mean, Roe is as bad today as it was in 1973. That's because it's maximally bad. There's no space to be worse. There's no insight that we can have, like, oh, you know what, I thought of something else. I thought of another reason why Roe v. Wade was bad. All the reasons are apparent right away in 1973. And so the bottom line is, but the sociologically important and politically important point that they make, though, and sorry to say, they say that women's flourishing, and this is what you hear, by the way, in the political debate. And this is what is most animating to participants in the political debate. It is clearly what is on the minds of people who are most agitated and upset at the prospect of Roe and Casey being overturned, is this idea that women need abortion. Women need abortion for their flourishing. Women cannot be successful in the United States without access to abortion. They cannot live in the way that men do and make the choices and forms of expression that men pursue, and then have the same economic and social future as men unless they have recourse to abortion. They have to have it as a mechanism of equality. Okay, he uses the phrase liberty, but it really is a kind of conception that's rooted in the principle of equality. So, and by the way, that is in some ways a sociological question, right? Does he marshal evidence? Is there data that shows how successful women become once abortion becomes available and how unsuccessful they are when abortion is not available? No. There's not meaningful social science data in Planned Parenthood versus Casey to that effect. There's one citation that relates to contraception, but you don't know that unless you pull the study and you read the study. It's completely unsupported. It's rank speculation. And it ignores, by the way, the fact that there are enormous legal changes and, thank goodness, cultural changes in the status of women well predating 1973, involving non-discrimination laws, involving a whole host of laws and practices that, of course, we're not done yet, but we're brought to bear on the question of allowing women to pursue their lives and their flourishing in a free and equal way to men. It wasn't abortion that did that. It was this host of other elements, and yet the court simply says, abortion. That's what it was. And by the way, there's a very interesting amicus brief in the Dobbs case written by these very interesting professional women who take issue with recourse to social science evidence the proposition that women need abortion for their flourishing. They find that insulting, and they show them, in fact, that that's not the case. But put all that to the side. That's where the court lands. And then the last thing the court said in Planned Parenthood versus Casey was, listen, we, the court, have found a solution to this vexed social problem rooted in the Constitution itself, and so now the contending sides of this controversy need to go home. Pro-lifers, go home. We've settled this. We've given you a little bit more wiggle room at the state level to pass laws involving informed consent and 24-hour waiting periods and parental involvement, not spousal notification, but the other issues that were challenged in Casey were all affirmed as constitutional, and some of them had been struck down previously under Roe. So they said you can do these ancillary things. You can get, as I say, waiting periods, informed consent, parental involvement, etc. But that's it. You can't ban abortion. You certainly can't ban abortion prior to viability. That's off the table, explicitly off the table. A woman has to have the ultimate choice to pursue an abortion prior to viability. Casey could not be more specific about that. Okay? So, it looked like that was it. Pro-lifers were despondent, and for years, Planned Parenthood versus Casey was the law of, is the law of the land. As we stand here right now, it's the law of the land. However, it's so vague and vacuous, the undue burden standard, it's not at all clear what it means. And then there's never even been a 5-justice majority for the proposition of what exactly constitutes undue burden. You can only understand it inductively by bringing a law, passing a law in your state, having it immediately enjoined by the district court, and then spending 2 years to get it to the Supreme Court. And if the Supreme Court takes cert, which they have the discretion not to, and then the court evaluates your case, then you will know if the thing that you did as a state is an undue burden or not. Now that is not a sustainable, functional, well-functioning republic where people have strong views on the question of abortion and want to govern themselves and regulate the question of abortion the way it is done around the world. But that's not permitted here under Planned Parenthood versus Casey. So over time, it looked like there were opportunities for Casey to be revisited or refined. There was no direct challenges to Casey. In 2016, there was a case called Whole Woman's Health versus Hellerstedt involving admitting privileges rules out of Texas and ambulatory surgical center requirements for outpatient abortion facilities that were pretty restrictive. And the court struck those down and then said in Hellerstedt, what undue burden means is just a freewheeling burdens and benefits analysis that we do as the court. Is the burden of this law justified by the benefits that it provides? That's entirely subjective, and it entirely depends on what you think abortion is or how valuable it is. But nevertheless, that was the law in 2016. People were like, what are we doing? And then in 2020, in a case called June Medical Services versus Russo, there was another fractured opinion. This involved a virtually identical admitting privileges provision in Louisiana, in which fractured decision 413, is that up to 9? No, it doesn't. 414. With Chief Justice Roberts joining the 4 liberal justices for the proposition that this had to be struck down. But Chief Justice Roberts had yet an even different vision of what the undue burden standard means. And so even today, we have no idea what the undue burden standard means or requires. In fact, there's a dispute among the lower courts about whether or not Chief Justice Roberts' concurrence is the controlling opinion or whether it's that of the 4 plurality justices otherwise. So fast forward to now, right? We had a change in the composition of the court, right? We had a new addition to the court. You may recognize our wonderful friend, Professor now Justice Amy Coney Barrett. And one of the cases that had been pending for quite some time involved a 15-week ban on abortion. Whether or not Mississippi passed a law forbidding abortions after 15 weeks. Now, why is that important? Why is 15 weeks important? It's because that is prior to viability. And we know that any fair reading of Casey, in my judgment, I'm editorializing, any fair reading of Casey draws the conclusion that you cannot ban abortion prior to viability under the plain language of Casey. You can't do it. Casey says you can't do it, explicitly says it. Okay? And the parties agreed to that. Mississippi said, this law, if this law survives, it means Casey has to fall. And then the Solicitor General of the United States, who's advocating for the abortion rights side, and the respondent in this case, Jackson Women's Health Organization, agree. They say, that's right, justices. You have a binary choice here. The phrase that the Solicitor General used was no half measures. You either strike down this 15-week ban and affirm Casey, or you affirm the ban and you strike down Casey, because they are squarely opposed to one another. Which is why the grant in this case is so dramatic. The court granted the question whether all pre-viability prohibitions on elective abortions are unconstitutional. In Planned Parenthood versus Casey, if I were giving an exam to my students and I asked that question, and they said no, they would get an F. The answer is yes. Under Casey, all pre-viability prohibitions on elective abortions are unconstitutional. So, before this week, the big question was, what's the court going to do? They had oral arguments on December 1st. It's a really terrific oral argument. All the advocates on both sides did a great job. And you could kind of tell from the justices' questions which way they were leaning, although you should really be cautious about that because you can never really tell which way they're leaning. They may be asking questions for different reasons. But it sure seemed like there were 5 justices who understood that there was a binary question here, that you either could affirm the 15-week ban, but if you did that, you had to strike down Casey and Roe, or if you were going to strike down, if you were going to affirm Casey and Roe, you had to strike down that 15-week ban. And so the 5 justices sure seemed like they were inclined in that direction. Now, one justice, Chief Justice Roberts, asked a question. He said, isn't it true that viability, the concept of viability, is not really at the heart of Casey and at the heart of our abortion jurisprudence? By the way, both sides said, no, Chief Justice, it is at the heart. It is essential. But he seemed to be trying to find some way in which he could both affirm the 15-week ban and also leave Casey and Roe undisturbed. That's not to say that he wanted to reaffirm them, but it could be the case he just didn't want to have to revisit those questions. He wanted to find the narrowest way to resolve the case, possibly. I'm speculating about what his motives were, but it's true, that's what it seemed like. And the only way to do that is to rewrite Casey, which, by the way, is not, and let me back up. So the arguments you hear right now in Dobbs are all stare decisis arguments. No one will defend the reasoning of Roe. They're not even really defending the reasoning of Casey. They're just saying, this law has been on the books for 50 years, and you're going to cause a massive disruption. Women have built their lives on the availability of abortion, and you're going to condemn them to a life of misery if you take this constitutional right away. They won't ever have the kind of equality they had when abortion was available. Okay? And that's a kind of stare decisis argument. But stare decisis is fundamentally about preserving a prior opinion for the goods of stability and transparency and overall sustainability of the legal system. It is not a doctrine of transformation. You don't reinvent the prior precedent to produce the same outcome. It's about, because if you're convinced that the reasoning was so poor and it's unsustainable and it's an unworkable standard and it's caused all these problematic effects, you overturn that decision. Plessy versus Ferguson, by the way, which was the separate but equal decision in the school context, a shameful decision, a stain on the Supreme Court's history, lasted 58 years before Brown versus Board of Education, the court exercised its authority and said no more. We are no longer going to say separate but equal in terms of racial segregation in schools is consistent with the Constitution. It is not consistent with equal protection. It's not consistent with the Constitution. It's an abomination, and we're going to strike it down. Now, was that disruptive? Are you kidding? In 1954, with respect, entire school systems built on the concept of segregation, it ripped communities apart. But it had to. That's the way that wickedness was going to be rooted out. Okay? And the justices had the courage to do that. So Chief Justice Roberts, if what he was trying to do is find some way of squaring the circle and keeping and not talking about Roe and Casey, but leaving the law in place, he'd have to abandon the concept of viability, which effectively means he's rewriting Casey, which means we're no longer in the world of stare decisis, we're in the world of something else. And so, what happened this week? Politico obtained a draft document, the first draft. So let me explain to you. So what you may already know this, but the case was argued on December 1st. The same week that the oral argument happens, the justices meet in conference, they talk about the cases, and they take a preliminary vote. And then they assign, and then the justice who is most senior in the majority block of voters assigns the opinion to one of the justices in the majority. Either keeps it for him or herself, or assigns it to somebody else. If the Chief Justice is in the majority, he assigns the opinion or he keeps it himself. The leak, and this is shocking, there have been leaks in the past, but nothing like this. Someone got this document, gave it to reporters, and then told the reporters what happened in that conference. They said there was a vote in conference, and 5 justices voted to overturn Roe and Casey, And it was Thomas, Gorsuch, Kavanaugh, Alito, and Barrett. And that Chief Justice Roberts was inclined not to go with them. It was not clear that he would strike it down. He might try to find the law constitutional, but under some different theory, which is a concurring opinion. It's not a dissenting opinion exactly. It'd be concurring in the judgment, and then dissenting as to certain propositions in the majority opinion. And then the three remaining justices, Breyer, Sotomayor, and Kagan, would dissent. So this is an unbelievable breach of confidentiality and ethics. The idea that someone would take this, and why did they do it? I mean, we can speculate all we want. It seems clear to me, Occam's razor, that the person who leaked this was trying to effect an act of disruption to try to destabilize the situation to bring about a result that he or she preferred than what the current situation was. The leaker told Politico that as of publication, the 5 justices were still on board with Justice Alito's opinion. So what the leaker was trying to do was to peel off, in my judgment, I mean, there are a lot of different theories, but my theory is trying to peel off someone in the majority so that Roe and Casey wouldn't be overturned, or failing that, to bring so much opprobrium and anger upon the court that it would lose its integrity and lose its legitimacy in the institution. And immediately upon the leak, you saw a coordinated effort. There were AstroTurf protesters that showed up at the court immediately. You had Chuck Schumer out there. You had Joe Biden with a statement already. Kamala Harris went to do an Emily's List event. These are not things that you can pull together in 12 hours, right? I'm not suggesting anything. I'm just making an observation that that's a very unusual confluence of events. In any event, people disagree. Other people have other theories about what would happen. That's my theory, for whatever it's worth, which is nothing, because it's rank speculation. So Justice Alito, in his opinion, says, we're overturning Roe and Casey. No grounding in the text, history, tradition, and Constitution. Roe is a terribly reasoned decision. Casey was also poorly reasoned. We're not bound by principles of stare decisis, rightly understood. Not only were they egregiously and grievously wrong, they've caused enormous problems, not just in terms of the massive loss of life, but also in terms of other jurisprudential doctrines that have been corrupted and bent in cases in which the issue is abortion. And so what we're going to do is we're going to give this back to the states, which is where it was for 185 years. The states are permitted to regulate or ban abortion, and we're going to take a deferential approach to evaluating their bans. We're going to use what is described as a rational basis test. We're going to affirm those regulations as constitutional if they are pursuing a legitimate interest, and he says the legitimate interests include protecting prenatal human life, defending the integrity of the medical profession, preventing fetal pain, preventing certain gruesome abortion procedures, and promoting respect for life more generally. Those are all reasons why you could ban abortion in America, according to, they would be a legitimate interest, a legitimate state interest. And if the means to pursue that legitimate interest is rationally related to that goal, we're going to affirm that as constitutional. And then he says, by the way, those of you who might be worried that overturning Roe and Casey might have adverse effects for other important privacy rights or rights that are unenumerated, like the right announced in Obergefell for same-sex couples to marry, or in 1965, the right to married couples or to use contraception, or single people or minors to use contraception. There are 3 different cases related to contraception in the 60s and 70s. This doesn't relate to any of those cases. Why? Because none of those cases involve the intentional killing of a human organism in utero. That's the major distinction between this context and that context. We explicitly state that there's nothing that is going to happen as a function of this opinion to those rights enjoyed by those individuals. Which, by the way, is important because in the political discourse what you hear is, now that Roe and Casey are going to be swept away, that means we're going to lose the right to contraception, that means we're going to lose the right to gay marriage. Just to be clear, for a right to be lost, what has to happen is a series of events. One, you have to have a state legislature introduce legislation to ban the thing that previously was recognized by the Supreme Court as protected by the Constitution. So that would require a lawless act on the part of the legislature to pass a law that was banning something that the court said was a fundamental interest, a liberty interest or privacy interest. Then you'd have to have that litigated all the way up to the Supreme Court. The court would have to take the case and then hear the case and then strike down and then reverse itself and then allow the state action to stand. That is an unbelievably Rube Goldberg kind of mechanism. And just to be clear, I follow these things pretty closely, I'm not aware of any jurisdiction in America that has proposed any laws like that. President Biden said, because of Roe and Casey, states are going to be allowed to segregate children in schools by their sexual identity. When his spokeswoman was asked what he was talking about, was there a law that had been proposed to do that, she said no, but quote, Republicans are capable of anything. That was the response. So if you're trying to weigh the future consequences and the meaning of this jurisprudential shift, and I should say, this is a draft, right? This isn't the final opinion of the court. Obviously, the person leaked it to try to change the final outcome in some way, in my view. Some have suggested to cement it. It doesn't make sense. But in any event, put that to the side. This is not a final decision yet, but if you're trying to evaluate what happens next, it seems to me you need to ask yourself, what are serious concerns and what are things that are merely scare tactics? And you should begin and end by reading the opinion and paying close attention to what it says. So the past 50 years has been a kind of tortured narrative of a result, right to abortion, in search of a normative rationale. Started out as privacy, moved to liberty, eventually kind of found its place in equality. And the standard of the rule at issue also shifted. Strict scrutiny, trimester framework in Roe, binary pre versus post viability, undue burden standard in Casey, burden versus benefit analysis in Hellerstedt, back to some completely unintelligible thing. We don't even know what it means in June medical services, bringing us up to now, right today. So we actually have not ever had a rule on abortion that we knew and could state with particularity what it was. But we did know that if the certain kinds of justices were on the court, they were going to affirm a right to abortion no matter what. And the argument that you hear in the public square is not even that the Constitution guarantees the right to abortion. What you hear is the right to abortion is essential and women need it. And it's going to be disastrous if they lose it. That's a policy argument. That's a normative argument. That's an argument that is better made in the public square. That's a better argument to make in the legislature. And that's what we're going to have to do if this holds and this becomes the final decision. We're going to have to govern ourselves on this question. And some states have already moved in that direction. You see New York, Illinois, and California have adopted sweeping pro-abortion laws that liberalize abortion up to 9 months of pregnancy, and specifically declare that the unborn child at any stage of development cannot be recognized as a person. Explicitly says they are not persons in the statute itself. Illinois will pay for abortions even if you're not a citizen of Illinois. And they've set up mega abortion clinics on all the different borders. So other states have gone in a different direction. Oklahoma has just passed the 6-week ban. Texas passed the 6-week ban. Other states have trigger laws that will ban abortion except for the health and life of the mother, or you have to look at the statute to see exactly what it says, upon the final issuance of an opinion overturning Roe and Casey. But this is just the beginning. This is just the beginning of trying to build a world. And let me just say one last thing. That those of us who are pro-life, because we believe that everybody matters. We believe that everybody counts, no matter who you are, no matter where you are, no matter how small you are, or how dependent you are, how weak you are, and definitely not in light of what other people think about you. We think everybody has an unlimited and unreplaceable value. And because that's the core of the pro-life idea, that has serious consequences for what we do when Roe and Casey is gone. That means we have to continue doing what we're already doing, which is not to say we haven't been doing it, but we have to double down and redouble our efforts to try to care for moms and babies, born and unborn, and families and communities, not just while they're pregnant, not just right after they're born, but to walk with these women and their babies, and hopefully the fathers are there too, and to care for them and to provide a civilization of love around them that reflects the core insight of unconditional love that animates the pro-life movement. So that's what we have to do. This is not the end, friends. This is the beginning. And this is the beginning of a way to prove to the world, to show the world that our unconditional hospitality, radical love of neighbor, no matter who they are, no matter what they think, no matter if they're a person who's had an abortion, or they perform abortions, or they disagree with us, we love unconditionally. That's what it means to be pro-life. And that's what we're going to have to do if, God willing, this decision holds. And we have the freedom through the law to care for women and babies and families the right way. So, thank you very much for your time.